Introduce our speaker, Juliet Robertson. Ms. Robertson started her legal career in the healthcare litigation and hospital administration, which has been integral to her success in estate and special needs planning and litigation. She began working in trusts and estates in 2010 and became her own owner of her own law firm in 2015. Juliet.
Good afternoon. I just gave this talk at one of the lunch roundtable things, and everybody had a great time comparing war stories about end-of-life situations. So I hope that you all benefit from this information. I'm not going to be discussing any new law or anything that just became law. I'm just going to be bringing your attention to the existing law, which I have experienced in my own practice representing professional fiduciaries, that they were like, whoops, I didn't realize that was how things were, and give yourself a place to check back in to understand. We're gonna discuss what is end-of-life decision-making, what documents are involved, what methods do the courts provide us for getting people care or withdrawing care, and then what are the limitations imposed on conservators for withdrawing care from somebody. If you have any questions or you have a scenario or something like that, please feel free to, wait a second, no, that's not working. Please feel free to raise your hand. I must admit that I submitted this presentation over a month ago and didn't realize I would be speaking for an hour and a half. So I'm going to try to stretch a few things out, and I appreciate audience participation if you feel like you want to weigh in on something. A little bit more about me. I'm a certified specialist in trusts and estates. I do planning, I do administration, I do litigation. I represent a number of professional fiduciaries in my region. My office is in Lincoln, California. For anybody not familiar with that area, it's just north of Roseville in the Sacramento Valley. I also have a small satellite office in Gilroy that I set up at the request of family and friends who just wanted a familiar person to work with. But I represent or I handle cases all over Northern California. I have been through a number of litigated end-of-life cases. And I also do a significant amount of work with some of the local medical centers that we have in our area when they have patients with incapacity issues and getting fiduciaries involved or making decisions on their behalf. So I like to start with what are we talking about when we're talking about end-of-life decisions. And it means entering DNR for someone. It means instructing a withdrawal of care, withholding of care, authorizing hospice, signing a post. Those are all mechanisms that we use as fiduciaries to take or to implement end-of-life processes, okay? What are some end-of-life states? Well, it's pretty much a spectrum. I mean, you know, we've got everyone from the competent but terminal, which are not likely going to be conservatees, right, because they're competent, but they may be consulting you as part of their healthcare directive. You've got incompetent people who are on life support but not persistently vegetative or terminal. You have incompetent and terminally ill people. You have persistent vegetative state. I call it PVS, is easier to say, otherwise I'm going to be spitting all over the microphone. But PVS and not otherwise terminal, so the body is living, but the brain is not communicating. And then PVS and terminal. So these are some of the terms that are going to get thrown around in this presentation and that you may experience taking care of your clients. The definition of PVS really comes from your physician, but here is a synopsis. It's a clinical condition that is a complete unawareness of self and environment. And there is some hypothalamic and brainstem function. I mean, I'm not a doctor, but I do have a science degree, and it's basically the brain is not communicating from a cognitive perspective, but it is communicating with the body. Patients in PVS also have no evidence of sustained or reproducible purposeful voluntary behavior. They're not going to point to something. They're not going to grab for something. unless it's with some sort of physical stimuli or pain reaction possibly. They usually have bowel and bladder incontinence, and some they may have some cranial nerve and spinal reflexes. It's usually 1 month duration before they will call PVS, but some physicians will more aggressively say, no, we're there, and you may have that in interaction. Recovery from being unconscious is unlikely after 12 months in adults and children, and recovery from a non-traumatic PVS state after 3 months is very rare. What are our mechanisms for making end-of-life decisions for another person? We're not really going to be we're not going to be talking about mechanisms for ending your own life, for making that decision for yourself. This is about what you as a fiduciary would be doing for another person. So we use power of attorney for healthcare. Oh, thanks, Michael. Always the gentleman. We have durable power of attorney for healthcare and healthcare directive. Now, some of you may have seen in your practices that these documents used to be two separate things. Estate planning that was done, 20-some years ago, which would still be effective today if it was done, in compliance with the law, would have a document that gave power of attorney for healthcare decision makings, which basically gave them the authority to make the decisions. And then it would have a separate document called a living will, usually, that would give the instructions for the care. Modernly, the code has combined those two together, and you'll see them combined in a power of attorney or a healthcare directive. They are named interchangeably, but that is the intended effect, is that you're giving authority to a named person to make healthcare decisions on your behalf when you are without capacity to do that, or presently, if you want to voluntarily give them that authority, although I don't know why anybody would do that, and then also giving them the specific instructions for how to consent, withhold, or withdraw care in the event the need arose. Next of kin are used, in hospital settings, in quick, we need an answer, we need a consent, something like that. Judicial authorization is used when we need authorization for a specific intervention procedure. I'm actually waiting for a call, which I won't answer, I promise, I'm being videotaped, from a physician, because we got a request in today to start processing a judicial authorization for a patient who needs a tracheostomy and a PEG tube. And so once that gets in place, then we will reevaluate the need for ongoing permanent fiduciary management or permanent healthcare decision-making, which would be a conservatorship of the person. But if this patient recovers to the point of regaining capacity and can start making medical decisions for him or herself, then the judicial authorization is all that was needed to get that person care, okay? So it's kind of a fluid process, and those are the different methods that we have for making end-of-life decisions. Power of attorney. When you get one of these things, either you have been named in it, or you're a contingent or something to that effect. You want to make sure that it names you clearly, that it has your contact information listed in it, that the instructions regarding end-of-life decision-making are specific and clear enough that you understand what they mean. I've seen a number of these documents that are so vague that they don't even work, or they're so specific that you're sort of appalled. I had one client who asked me to specify the ethnicity of the care providers that would be caring for her on a regular basis, and I couldn't do it, but we just worked with the existing document to the extent that I was comfortable. But do they have an expiration date? Are they properly witnessed? Are they notarized? Do they look like they're real? Do you see any weird pagination issues? The law technically authorizes an agent under a power of attorney for healthcare decision-making to withhold or withdraw care in accordance with the patient's wishes to the extent that they are known to the conservator, to the agent under power of attorney. We're not to conservatorship yet. There are also decisions must be made in accordance with the patient's best interest. Now, making decisions under a healthcare power of attorney is very different in the eyes of the law than making decisions under conservatorship. Power of attorney is something that that person voluntarily executed. They made the choice to appoint you and to give you the authority to make those decisions for them. They are not having someone imposed upon them following removal of their civil rights and a determination of incompetency, okay? So the standard for how you as the agent under the power of attorney make the decisions to the extent that you know their wishes and in their best interests, it's a lot more flexible and you have a lot more discretion. But as we all know, that best interest standard often leads to litigation, especially if you have children or siblings of the principal or parents of the principal or somebody who disagrees with what you're doing. So, you know, if that does occur, then you're going to want to go and get a court order. The trouble is, remember that with healthcare powers of attorney, you cannot force treatment on anyone. So if you have a principal, the person who signed the document, if you have them and they are capable of objecting to what you're doing or weighing in on what you're doing or contradicting their instruction or anything like that, you need to go and get a judicial determination of incompetency and get a conservator appointed, because the healthcare power of attorney is very easily undone by litigation and by people contesting what it says. Let's see, if they don't have a directive, then what are our methods? Well, we talked about next of kin. That's often hospitals' first line of answer or action is, where is someone who knows this person? I mean, I've had situations, unfortunately, where they're pulling the neighbors in. Hey, can you authorize discharge to this facility? Or hey, can you authorize this surgery? They would have wanted it, right? You know, you basically have this flurry of activity to find somebody who knows this person and can articulate what they may have wanted and is willing to sign an informed consent. Families can also consent in a skilled nursing level facility without healthcare directives. Again, if they're in conflict, if they're not all holding hands or on the same page, then we have potential litigation and possibly the need for a conservatorship to establish a primary decision maker. We talked about judicial authorization. Judicial authorization is when we have nobody that's willing to step forward to make a decision or that we believe is credible and trustworthy, and we need to give informed consent for medical treatment or an end-of-life decision even. I've done judicial authorizations for end-of-life where we have somebody who is really teetering on PVS and the whole process to conserve them is really futile. But the hospital is typically the petitioner, and but it can be another related party, but it's typically the hospital because they're the ones that want to get this person, their care needs addressed, and there is a best interest standard. There's a court-appointed attorney for the patient who goes out and visits them, and then usually, most cases, we're just asking for the ability to treat with medical treatment. I had a case recently where the lady, she had a cancer in her voice box that was precluding her ability to breathe and swallow. And she came in having been found down, basically unconscious from not being able to breathe. And this cancer was very aggressive, and she didn't have much of a quality of life. And the surgeons were proposing a treatment which would surgically remove that tumor and her voice box. So she was homeless and female and led a very promiscuous life. And to send her back out onto the streets with no voice box was it really pained the judge to weigh that against doing nothing and allowing her to pass. But ultimately, the treatment was ordered, and she got it, and she is now living with one of those vibration machines. And it was a hard case to be involved in, but I think it had the right outcome. So conservatorship of the person. This is where I'm going to spend most of the time today, because this is where you have the most restriction imposed upon you. There is case law. Now, the case law is not new. I mean, these are cases from the 80s, and then the most recent case, which is a seminal case, is 2001. And basically, it was a situation, which you're probably familiar with, where the conservator makes a decision to DNR a patient or to withdraw a feeding tube or something, and then family members learn of it, and they rush to the courthouse and file an objection to put a restraining order on that process from happening, having the conservator removed or whatever. I'm going really fast. So the case of Drabeck was a situation where the conservator wanted to remove life-sustaining care from a conservatee who was in a persistent vegetative state. And the court said, we're going to look at the best interest standard, and because there were no wishes to the extent known, and they decided that PVS was pretty permanent and they were okay with withdrawing care. That case was applied in the conservatorship of Morrison, which really just made the same finding, except it was a situation where a religious-centered hospital was refusing to allow the conservator to withdraw the care, and so the court said that the conservator had the permission to transfer the patient to a different hospital to have the care withdrawn. So those two cases sort of set the stage for the seminal case, which is Wendland, which is from 2001, and this is the one which I'm really going to focus on. It was a case of a conservatee with non-PVS, which means he was incompetent, but he was conscious. And it really focused on the interpretation of Section 2355 of our probate code, which is that section that you see on all of your conservatorship orders that gives you the medical decision-making authority. The case was similar to what I just explained. It was a guy, I believe he was in his 50s, early 60s, and he rolled his truck in a high-speed solo accident while driving under the influence of alcohol. Apparently, he had just lost his father-in-law, who was an important person in his life, and he went on a drinking binge as a result of it, and his family tried to rein him in, and he was like, they were telling him, look, you're just going to get in a car accident and you're going to, hurt yourself and become a vegetable, and you don't want that, and you need to stop this drinking and this and that. And he would yell at them, don't you ever let me get to that point. If I go out and drive like a crazy man and I get myself hurt or killed, you don't ever let me stay in that as a vegetable. Well, what ended up happening is that he became a vegetable, and he was dependent on artificial nutrition and hydration. He was severely disabled. Wife got conservatorship of him, and she instructed the physicians to remove his feeding tube. And then his sister and mother said, no, you can't do that, or we're not going to let you do that. And they went to court and filed for a court order to restrain the conservator from, or the conservator and the physicians from carrying out that instruction. Robert made conservatee Robert made some improvements in therapy. But he was still severely disabled mentally and physically, severe cognitive impairment, had motor and communication problems, agitation, severe paralysis on an entire left side of his body and moderate paralysis on the other, impaired communication. He was compulsive with his movements, severe swallowing dysfunction. He had a feeding tube that he was dependent on for his nutrition and hydration. He was incontinent of bowel and bladder. Well, some of the same things that we heard in that PVS definition, but not completely. Mild to moderate contractures of his body and limbs, bladder infections, recurrent pneumonia, sinusitis, dental issues, everything short of bed sores. And he was really not in a good place. Well, he had several surgeries. The wife had to authorize surgery 3 times to replace the dislodged feeding tube. And she was just like, with the consultation with his brother and other people, she decided to appeal the decision. Well, they went to trial, and the court found that there was not enough evidence to withdraw care. And so the case was appealed, and the trial court basically said that there was no clear-cut guidance on how to evaluate a conservator's proposal to end the life of a conscious conservatee who was neither terminally ill nor in a persistent vegetative state. And so it got appealed and went all the way up to the Supreme Court. The doctors testified that he was in a minimally conscious state and did have some cognitive function, the ability to respond to his environment, but not to interact in any sort of proactive way. And then they also took testimony from his wife and his mother and his sister and his brother. And the wife and the brother and the daughter, discussed his attitude towards life-sustaining care. They talked about the fight or the verbal exchange between him and the brother about, he said, Mike, whatever you do, don't let that happen. Don't let them do that to me. And that was in response to the brother saying, you're just going to lay in bed like a vegetable because you're going to get hurt so bad drinking like this. His wife recalled him saying, I would never want to live like that, and I wouldn't want my children to see me like that. And look at the hurt you're going through as an adult, seeing your father like that. So he was relating the experience that he had with his father-in-law's passing. He said he wouldn't want to live like a vegetable, wouldn't want to live in a comatose state. These were all quotes that they took in trial testimony. He said that if he could not do all the things that he enjoyed doing, like the outdoors, feeding himself, talking, communicating, he would not want to live. Well, the court looked at the probate code section 2355, which was different when Drabick became law in 1988, but was after that modified by the legislative folks, and there was comments within the new version of the probate code section that said that it's to be consistent with Drabick. And so the current definition includes healthcare decision and healthcare as what the conservator has the authority to do. And in the healthcare decision, it says a decision made by a patient or the patient's agent, conservator, or surrogate regarding their healthcare, including, and skip to section C, directions to provide, withhold, or withdraw artificial nutrition and hydration and all other forms of healthcare, including CPR. That would seem very clear that the conservator has the authority to withdraw care in any situation that in their discretion was in the patient's best interest, or to the extent known to the conservator, the wishes of the conservatee. And that's where this court got hung up, was with to what level of evidence do we need to prove or hear that this decision is consistent with the wishes of the patient or in the patient's best interest, okay? And so they got they did a very in-depth analysis between the difference between being appointed as an agent under power of attorney at the volition or choice of the patient and being court appointed by the county to make decisions on behalf of an incompetent person. It was the difference of the agent for healthcare has a very preponderance of the evidence, lower standard of evidence to prove that their decisions were made in the best interests or to the extent of the wishes of the patient. But then when you get to a conservatorship, consistent with other states' rulings, believe that the right to life is consistent with the right of privacy, which is a constitutional right in California, not to have your privacy or your person invaded by the state or others, and that every constitutional right, when it's taken away, requires a very heightened level of proof of evidence which would be clear and convincing evidence. The when the legal premise or the grounds for a conservator's decision to end the life of a conservatee is that the conservatee would refuse such care, then to apply a high standard of proof will help to ensure the reliability of that decision. Okay, the state always defaults to preserving life. The function of a standard of proof is to instruct the fact finder concerning the degree of confidence our society deems necessary in the correctness of factual conclusions for a particular type of adjudication, to allocate the risk of error between the litigants, and to indicate the relative importance attached to the ultimate decision. That's the court saying, look, we just want to be really, really, really sure, because this is an irreversible situation that you're asking us to consent to or to order. The court went on to, evaluate law from other states and the existing California law, and it said that only when the patient's prior statements clearly illustrate a serious, well-thought-out, consistent decision to refuse treatment under these exact circumstances or circumstances highly similar to the current situation should treatment be refused or withdrawn. So pretty much the court decided that the testimony of the brother and the wife, and I believe the daughter, did not amount to clear and convincing evidence, and the court declined to allow her to remove the feeding tube. The constitutional considerations of invading a person's right to privacy and to have the right to their own self-determination was paramount. They also, and that was clear and convincing evidence to prove up whether the conservator was acting in accordance with the wishes of the patient, of the conservatee, to the extent known to the conservator. So, reading in the ruling the comments about having a statement that's documented, what are some options for you having clear and convincing evidence in your files of a patient's known wishes? That would be prior healthcare directives that, even if they have been revoked, you could use for the content of them. Healthcare directives are often revoked as to the authority of the agents only. They rarely change the instructions unless there's a formal order changing those instructions. Rarely are pre-incompetency comments enough to prove up clear and convincing evidence. The court says in the opinion it wants legally cognizable express documentation of the person's wishes. I haven't really tested this on a case insofar as maybe you get appointed on a conservatorship with a conservatee who has dementia or Alzheimer's but is not completely unable to communicate with you and can have some kind of conversation about what they would have wanted or what they do want for end-of-life decision-making. For some people, that's a very instinctual decision, and you might be able to consult with them in the presence of a neuropsychologist or something and see if something cannot be documented on their behalf, which would satisfy clear and convincing evidence. It's not necessarily too late to do that when a conservatorship is established, but you are taking chances when you try to create evidence after the fact. The court also considered the best interest standard because, remember, in that 2355 section, the standard was for to the extent known, the wishes of the patient to the extent known to the conservator, and then the other was in the best interests of the conservatee. The court examined the best interest standard to see if this decision or request to withdraw the feeding tube was in the best interests of the patient. And it just flat out said, we're not even going to go there because ending somebody's life is not something that we can even consider is in their best interest. So it was pretty much written off as a possible evaluation. And then lastly, the court did attempt to contain its ruling. It said that the decision is narrowed to conscious conservatees who have not left formal directions for health care and whose conservators propose to withhold life-sustaining treatment for the purpose of causing their deaths. It does not affect permanently unconscious patients, which would be the PVS patients, persons who have left legally cognizable instructions for healthcare decision-making, or conservatees for whom conservators have made medical decisions other than those intended to bring upon their death. So, you pretty much have a whole lot of discretion when it comes to consenting to care, but when you want to withhold or withdraw care to end life, that's where you need to really evaluate whether you have clear and convincing evidence to do that, and then whether or not you need to pursue a court order. There is a case that was for a guardianship of the person. I brought this up just because I know some of you also handle guardianships, and the ruling in Wendland was carried forward in Ray Christopher I, which was a very, very disturbing case of a young child who was essentially shaken to the point of being in PVS by his father, and they ended up requesting withdrawal of care because the baby was PVS. And they decided that clear and convincing evidence standard applied when withdrawal of care was in the best interest of the minor. In this case, they used the best interest standard because you wouldn't know what the wishes were of a infant child. But they decided that the baby was permanently brain dead, and that withdrawing care was basically what's the word I'm thinking of? Humane. Yeah, was compassionate. So how do you handle a case where you have a suffering, non-persistent vegetative state conservatee? Well, you sort of have to first err on the side of understanding that the law requires that you continue to treat until you get to a point where you can legally withdraw care, or you start your research and documentation of what their wishes were and whether you have clear and convincing evidence of that. Communicating with their physician, researching prior admissions. They're getting very aggressive nowadays about getting healthcare directives for people as they come into hospitals. Posts are good evidence of somebody's wishes as long as they're signed off by a physician. Researching whether they have any prior estate planning, whether it's in place or not. Trying to have a conversation with the conservatee and find out if they are at a point mentally where they can communicate their preferences to you, and then possibly memorializing that with some sort of, I don't know, it's getting extreme, but possibly a video conference or a video deposition or a consultation with a neuropsychologist who can document that in a report of some kind. Just try to think of everything. If what you're trying to achieve is the ability to withdraw care. Court intervention, I have sought authority to withdraw care for a conservatee, but he was right at the precipice of PVS, so we were able to get a court order that said upon PVS setting in, we would just withdraw care. But it was partially to appease the doctors, right? Because the next slide is where we'll discuss all the pressures that you deal with in making these decisions. You can often consult with court-appointed counsel for the conservatee. They can support requests of the court. The courts do not like to get involved with this stuff. That's really part of the problem, is that within the commentary in our legislative history in Probate Code 2355, the courts don't want to be involved in the medical decision-making. They don't want to determine if something is appropriate or not. So they really hate it when you ask them to make end-of-life decisions. And so you try to tee it up in a way that the court will sort of feel like somebody else is making the decision for them and they're just kind of letting it happen. Physician declaration, you're going to need that for any court proceedings. The physician declaration would even be important for your file, potentially, if the medical records were not clear enough as to the state of the patient. Oftentimes, they would potentially be non-committal about whether the patient was PVS or not. And so you would want to get something that was sworn under penalty of perjury so that it could be potentially used as evidence in support of your case at a later time. The input of family and friends regarding the wishes of the patient, I mean, we just saw in Wendland that really doesn't hold up without additional evidence of their intentions. But sometimes that can help you understand what somebody would have wanted, and it can ease your distress about giving them more care. Some people, I'm always surprised when clients instruct me to give them any and all life-sustaining treatment possible, regardless of whether it will provide them any quality of life. There are people out there who want that miracle or who don't believe that they're mortal. Like I said, your prayer for relief can basically say, give you the authority to enter DNR so that when there is some sort of event or seizure or heart attack, that there wouldn't be resuscitation or withdrawal of care upon PVS setting in. Both of these are iffy, but it would definitely be in the court's discretion. Sometimes we file these things just to get them in front of a judge to, keep certain parties at bay or to get the facts all out there, especially when we have all of these other pressures coming at us, right? I mean, there's the harm of further invasive treatment, right? We had a healthcare agent who was repeatedly discharging her mom from the hospital and then within days or hours calling 911 for the paramedics to come back out and re-intubate her. And I think she had been intubated about 6 times in about 2 weeks. And the doctors were like, this is barbaric. We are ravaging her esophagus and causing more harm than we are doing good, and this is contrary to our oath. You may hear that a lot. The doctors are like, this is against my oath. I can't participate in this or whatever. It's all do no harm. And sometimes you have to be like, I'm sorry, this is what the legal requirement is for me. But we were able in that situation, that was a healthcare power of attorney situation. So the hospital was able to file a restraining order against the daughter, which essentially asked the court to command her to follow the wishes in the healthcare directive. We had another case similar to that where we had to file for removal of a power of attorney or an agent under power of attorney because he was doing exactly the opposite as what the healthcare directive said. And it was because, according to him, he could not imagine his life without his mother, and she was going to come out of this, and he had second opinions and all of this stuff. But lo and behold, he was talking to the doctors and then had his hand in her bank account and under power of attorney for financial management. So that was all going to stop when she died. So he was keeping her alive to keep his authority over her accounts intact. He ultimately retained counsel, and we were able to scare it into the attorney that if he did not do the right thing, that he was going to have a elder abuse label on him with a court order, and then that was going to potentially kick off a financial elder abuse investigation by APS, and that probably wasn't something that he wanted to be involved in. But still, it's that it's a lot of this stuff comes from the treatment team wanting you to let somebody go, or to, we had a case recently. I got a text message on Memorial Day, and it was, so-and-so who is a conservatee, who is demented to a violent behaviors, dementia, and he was presenting from his board and care with advanced sepsis and overall decline. The doctors wrote him off as soon as he got into the hospital. And I said, you know what to do. We've had this conversation. He's a full code. And she had to communicate that to the hospital. And pretty much 2 days of all of the intensive treatments, and he's walking back to the board and care. So had she not done what she was obligated to do by law, which is assess that he was conscious and or non-PVS and non-terminal, and that he was basically, she had no reason to believe, to a clear and convincing evidence standard, that he would not want care in that situation, she was obligated to instruct full code. And the funny thing is that his 2 children, who are estranged, thanked her and told her how appreciative they were of her standing up to the doctors and giving him a chance. And then she was also like, well, maybe it is his time or whatever. I said, no, you can't even think about that. If you think that this is going to happen again, and you're concerned about being put in that same situation again, then you need to start doing your research and your file building to determine if there is any clear and convincing evidence out there that you can come into contact with to support withdrawal of care in the future. Okay. We also had another case recently where a very elderly woman was conserved. She was basically bedbound, nonverbal, didn't really engage with her eyes, responded to stimuli, had a feeding tube. She was discharged to a assisted living board and care type situation. And as soon as she got there, they're like, we want you to sign a DNR. It's required. We have to have it on file. And, in the usual situation, this lady didn't have anybody. She didn't have children. Her spouse was deceased. There was a financial elder abuse perpetrator who lived down the street from her but was being prevented from contacting her. She didn't have anyone that the court would have perceived as relevant and as interested, like family or friend or biological relatives or heirs, but she had a church, an entire church community that wanted notice of all the ex parte proceedings, that came to the hearings when we established a conservatorship, and that would go to her bedside at least once a week and sing a mass to her and do prayer. And when the facility said, give us a DNR, who do you think was right in front of my conscience or my eyes when I gave the client that advice? I said, this is the last person that we are even going to try to DNR in these circumstances. You can't risk it. And so she was full code, and the facility was really disgruntled, but you have no choice, is what I'm essentially trying to give you as arms, as stand back, this is what I have to do kind of thing. Also, you've probably been in situations where the financial strain on a hospital is coming through in its recommendations for patients. We really need to move this guy on, or we really need to do this, or that surgery is really cutting edge or whatever, and you can't let that be a concern. Some of my clients, or some of the people that work with us in the healthcare situation, often get put in situations where they become involved at the by the hospital instituting the procedures to get them appointed, but then they have to make a decision that's adverse to the hospital because they've got to advocate that patient's best interest. And so you have to be prepared to really stand your ground and to meet all those fiduciary obligations to the patient. there are often financial strains on the estate for making decisions, but you can't really contemplate those too much when you're dealing with matters of the person. It might affect, where you decide to place somebody or what kind of care levels they get, but you can't lean or make the excuse that he wouldn't have wanted this because it's going to cost more money to the estate, or because that's often where the family waiting to inherit the estate will come forward and say, can't you put him somewhere cheaper, or this is our inheritance that you're spending. And it's really, to me, it's emboldening for a fiduciary to hear that kind of nonsense from a beneficiary. But you may be in a situation where you're wearing two hats. You have, you're doing a trust administration for an incompetent trustor, and so you have some obligations to the contingent beneficiaries, but then you're also making decisions of the person and using the estate for his or her benefit. And then conflicts between physician opinions and the legal restriction on decision-making authority. Nobody, not to offend doctors or social workers or people that are in healthcare, but nobody really understands the law and the probate code especially, and how it pertains to how you are supposed to do your job. Many social workers will make things up. I get families coming in, they say I'm responsible for this and I have to do this and I have to make this decision and that decision, and really it's just them responding to the pressures that they have from the administration to move patients on or to get the discharge planning done. Physicians are the same way. They may have had a really hard go with patients, or they just feel like they're not making any progress. A lot of doctors want to be the hero and save everybody, but if there's a particularly difficult situation, or if they're not, if they have compassion fatigue syndrome or something like that, they may put a lot of pressure on you to change the situation of a patient. I'm going way too fast. We're going to have to think of a lot of questions, so I hope you have a lot of questions about this. Let's see, what else? This is the slide I usually end on. By the way, just to condition the shortness of my presentation, I thought I was only talking for an hour, so I apologize that I'm a little bit short. Why should you care if nobody's really watching? You have a client who has nobody. Nobody ever checks on them. Nobody ever contacts you. The doctors don't care. The nurses don't care. The social workers don't care. And they're just going to say, here, sign this. It's all over. The estate is spent. It's all just your care and compassion hanging in there. You should do this, and you should do the right thing because it's the law, because litigation is the worst place you'd want to be in, and because it's your license. I mean, this is the essential core of being a conservator of the person, is making healthcare decisions and keeping somebody doing the right thing for somebody, and it's just expected. Try to think. Does anybody have any questions or comments or personal situations that they've been in with this exact stuff? Yeah.
I am conservator for a woman. She's now 92 years old, full-blown Alzheimer's. She did from the day I met her. She had a physician that had been a family physician for over 20 years, had dealt with her husband as well. I had a care manager on this case, and she thought we should get a pulse, which I did early on. And the doctor, we talked to the doctor.
Right.
So, it was
Right.
surprising to me.
Yeah. The post is, when you're the one signing it, it's probably not allowed. When the patient is the one signing it, that's your clear and convincing evidence. So,
Now, but at the time, you're guided by a care manager who's been in business, over 15 years. And the doctor who is signing it, knowing that the patient is not signing it, and here the hospital is saying it's all legal.
right.
So I gotta say I was shocked. I mean, now I know, but that was
Yeah.
the only time I've ever done that. But still, I'm glad I had an attorney who was on top of it. Nobody would have challenged it. That wasn't even the point.
Right.
It was not knowing that all.
It was very uncomfortable that you found out you were doing things illegally in those circumstances. Yeah.
And the goal that my attorney said is that she's gonna have to go full code, which means that she would have had to have a feeding tube. And at that age, that would have been pretty, horrendous for her. And to my surprise, and everybody's surprise, she's not doing fine. That's 11.5 years. She's eating. It's amazing. So had we done the surgery, she might not have.
So the court allowed the DNR to be entered, but she's still ticking. Yeah. Yeah. Yeah, isn't that ironic? The PULSE is the physician's order regarding life support treatment. I believe that's what it stands. Life-sustaining treatment, thank you. And it's usually hot pink or pink. It is typically admission-specific, which means that if the patient has capacity, the doctor will counsel with them about their end of life, if they were to code on the table or if they were to stroke out or do something during their hospital stay, what life-sustaining measures would they want or not want. And a lot of people, I live near or work near a retirement community, and a lot of the geriatric care nurses and such that are working in that community, they're like, go get your PULSE signed and bring it home and put it in your freezer and, put it on the front porch. And I'm, with the exception of this reason, needing clear and convincing evidence, I'm not the biggest fan of PULSE. I think that if you have a healthcare directive, you give the agent as much authority as they need to make those decisions for you, because PULSE can often contradict what healthcare directives say. So you want to make sure that they're consistent. But why people have them at home is that they're actually a doctor's order, so that if the paramedics come or are called to the house because somebody is found down and they've got a physician's order that says do not treat, they can just walk back and leave them there, and then the coroner is the next person to visit, rather than being obligated to put them into the ambulance and take them to the hospital to be treated or declared. So most of my clients are not so advanced with illness that they would not want a chance at being taken to the hospital to be worked on. But the PULSE is an expression of their desire to be treated or not be treated if their life is threatened. And how would they want that? It's broken down. Do you want artificial hydration and nutrition? Do you want all artificial or all life-sustaining treatment withheld? Do you want life-sustaining treatment in this condition? I mean, it's kind of this, it's a form, it's standard form. You can Google it and it will come up with a PDF, and you can read all the different, it's check boxes, and then the patient signs and the doctor signs.
So, California Coalition for Compassionate Care, which is an organization that's done a lot of PULSE education and training. There are a lot of volunteers in the community that can do education. They have a lot of amazing resources on there. And now doctors and nurse practitioners are allowed to sign a position that was changed this last year as well. So California Coalition for Compassionate Care, a lot of great education and training for both healthcare providers and individuals on the PULSE.
Yeah. Yeah, but back to her point, if you are signing as a fiduciary, you are authorizing them not to treat the patient in the event of a life-threatening situation. So that's technically considered withdrawal or withholding care.
But I think the thing that was surprising is that I had a, very knowledgeable care manager with him and a doctor who said, go ahead, yes, this is important to you to do.
Yeah.
So,
Yeah, it's also policy, like they're pushing those. They want them in there. They want documentation. They want the ability to withdraw care or to do whatever. I had a recent situation with a assisted living facility that had an egress or a secured perimeter unit on it. And I got a very distressed call from a client whose boyfriend was recently taken out of his home and admitted to this secured perimeter egress unit. And she was beside herself. She said he doesn't want to be there. The facility is telling us that the son is in charge and that's who they're going to listen to. And every time he tries to leave, they like corral him and confuse him back to his room. And, you know, she's like, there's no interaction and he's locked in his room and he only gets meals at certain times. And I just want him to come home and he wants to come home. And so I said, I'll come visit, you know, I'll see what's going on. And sure enough, I get there and he's sitting in the front reception area and she's standing next to him with her little walker. And there are like 4 administrators just hovering around them. And I was like, well, you know, I'd like to go to the room and speak with them. Oh, we prefer that the family doesn't want you to have any one-on-one communication with them. They don't want any isolation and this and that. And I said, okay, well, you know, I think I'm entitled, and his privacy entitles him to have me visit with him. And so they let me through. I mean, we're in the same community. It doesn't benefit them to make me mad. So then, you know, we go up to his room and we just start chit-chatting, and he's telling me that, you know, he's making a case for himself, right? Like he's obviously not able to do some stuff for himself and would probably benefit from assisted living, but really wants to go home to his pets and his garden and his, you know, recliner and all this stuff. And they had brought in a bunch of his furniture and stuck it in this really sterile room and whatever. But the point is that I went downstairs and I said, so what authority do you guys have to keep him here like this? What do you mean? I said, well, you realize that he can just leave. Is he under conservatorship? No. Well, his son has no authority to keep him here against his will. What do you mean? We have a healthcare directive on file, and the son's the authority, and he told us that he's going to stay here. And I said, oh, okay, I understand your position. So I sent him a little nastygram, basically saying you might want to present this to your legal counsel, but healthcare directive does not enable you to force care on anyone or limit their movement. And if they're objecting, you have to go and get a judicial determination of incompetency to be able to force anything on them. And I didn't get a response, but you know, he agreed to try it out for a couple of more weeks, but I think he's still miserable there. But it's the same kind of misperception that this healthcare directive empowers the agent to overrule the desires of the principal. You know, if somebody is able to form words that say, I don't like what you're doing, or don't touch me, or you can't make me stay here, or whatever, then you can't do anything. You have your hands tied and you cannot put together some type of conspiracy plan to trick them into doing what you want. And then you would have to pursue conservatorship, and hopefully that healthcare directive has a nice little provision that says, I nominate this person as my conservator, because their attorney has explained to them, if you're ever in a situation like this, you would want this person to be serving in that capacity, because when you had your wits, you wanted them to help you. But it's the same misperception. They are looking at it like a business transaction. They want to keep the person there. They think they have legitimate authority from the named agent on the healthcare power of attorney. They perceive the person has no capacity because they have one of those, help me with the number, the form that the doctor fills out to get them admitted to that kind of care facility. 602. And so, you know, they're like, oh, we're good. The agent's power is in effect, and they can tell us and instruct us about everything, when really it's exactly the opposite. A lot of times, you know, we'll go in to the hearing on a conservatorship, and we'll find out that the care facility that we place the patient in or the conservatee in is actually secured perimeter, and they don't advertise that they are, but by nature of the way that the gates work and have delays, and the fact that a staff person comes out and corrals people and doesn't let them come freely and that sort of thing. Recently, our Sacramento County judge was like, he put it in the order that the facility, any facility where this conservatee is staying must be informed in writing by certified mail that this person can come and go as he pleases and have any visitors that he chooses. And because he wasn't making dementia authority orders. And so, you just have to be really careful about it. You may have to inform your providers. You may have to educate them about your limitations, the restrictions on your ability to make medical decisions, and then, do your homework on whether you have any other evidence of clear and convincing proof. Right. Well, and you got a court order. Right.
Had a care manager, but, now clearly I understand that was not the case.
Right.
All the other cases.
I'm impressed that you got a court order because that allowed for the DNR to be signed or whatever.
That was part of the information. I mean, fortunately, the judge let me speak, and the daughter was there. So the judge asked the daughter, and we presented everything of what the committee had said.
So that judge thought that was good enough. Yeah.
The other, that same attorney of mine had another judge that said absolutely no,
Right.
feeding tube has to be put in, and it was.
Yeah, there was a case I was talking to another attorney here who said that they had a 5-day trial on whether a daughter could remove a feeding tube and allow mom to pass. And the judge said, I let everybody say what they were going to say, but not once did I think this case had clear and convincing evidence, so I'm denying, and mom's going to live. Yeah. Persistent vegetative state. Wow.
She had a brain bleed. She lays in her nursing home staring at the ceiling. She's on a feeding tube. She does breathe on her own. Her eyes are open. One child, of course, they're bothering me. There's an old poll signed by a previous conservator from full code. No directive was ever done, prior. One child says she wouldn't want to be kept alive artificially, which she is being now.
Mhm.
Artificially, and another child says, pull everything, if something happens, I want everything done. So there she sits, in her code, they ended up doing CPR, she's tiny little Chinese woman, they ended up doing CPR on her, they break every bone in her body, and it's really sad.
I would take that case. I would go get a DNR.
Yeah, but if one child says no,
It's a clear. It's all about what the patient's wishes were.
we don't know, that's the problem.
But in that case, you have case law that says you get to use the best interest standard with the PVS condition. So if you have a medical declaration that says she's been in PVS for 7 years, and the risk of further harm and CPR and that sort of thing is increasing with every day, then I think that's compelling.
I'm not trying to remove the tube, I just don't want them to do full code on it. Yeah, I don't want to remove the feeding tube. I just don't
Right. That brings up another point. In this decision, this Wendland case, the court kept mentioning and then backing off of what do you do when the conservatee has a terminal illness. Okay? It didn't make any ruling to that effect which specified terminal illness. But the way that terminal illness was mentioned, it says from a conscious conservatee who is not terminally ill or in a persistent vegetative state, it almost sounds like the court wants to create another category which would support a lower standard of, or allow you more discretion in entering that DNR, or just saying, the facts that I would perceive would be you have a conservatee with colon cancer or something. The doctors are saying that they're too old or frail to operate on it, and they're just going to live out their life. Saying no heroics or, medicating only for comorbidities or infections, things that basically allow the terminal illness to take its course, might be an option. In that situation, if there were children or interested parties contesting that or, saying we want the surgery, then I would probably go to court and get a court order which would allow for some sort of care plan which would effectuate whatever you were comfortable with. Yeah.
So it sounds like the
advance directives are the best evidence, or one of the best. We're on the receiving end as fiduciaries of estate plans that have already been put together. Very often, they don't have advance directives, because people don't like to think about those things, or whatever. So, given that we have, various levels of competency and various levels of ability to sign things depending upon the competency, and that we're the fiduciaries, what can we do to see to it that those advance directives are done, and what conditions would have to be in place for that to be okay? I mean, do we just tell them, you should go to your attorney and get advance directives, or?
If it's that important to you, you might want to say that you would not want to be appointed if they didn't have an advanced health care directive executed with their other documents. Just to sort of, be like, I'm serious about handling everything for you and not just the financial piece. Or, if you're already acting because of waning capacity issues, you may want to see if it's possible to sit them down with a neuropsychologist and find out if they're able to give instructions regarding end-of-life decision-making. Because remember, there's different levels of capacity. There's testamentary capacity, medical decision, put those together. Testamentary and medical decision-making capacity are probably pretty close to each other. And then there's contractual capacity, which is way up here, which is managing finances independently. And so you can often lose capacity to manage your finances, but you may still have medical decision-making capacity. And it's really, can they might not be able to appoint somebody, understand that they're giving over authority to make healthcare decisions for themselves, but they might be able to express their preferences and wishes if they can appreciate, risks and benefits and contemplate what it means to die and that sort of thing. But that's why I say have a good neuropsych that will not charge you a mint every time you call them to possibly weigh in. Yes.
If as a conservator you lack the authority to sign a false form, you also lack authority then to include people in a hospice program.
Yes, that was one of the end-of-life decision-making.
So we'd say yes, you have no authority to.
I would say that hospice is typically for terminal illness. Hospice, right? It's usually, to be a candidate for hospice, you have to be within 6 months of death or something to that effect because of late-stage dementia. Okay. I would say that it's case by case, and that, I've heard of hospice cases where they authorize hospice and then the person bounces back and they're in hospice for 2 years, and so really you have to look at what the hospice is achieving and whether you're managing the side effects of a terminal illness taking its course, or whether you are accelerating death, or what, you kind of have to, I would discuss it with your attorney. That's why that terminal illness component that's not really well included in this decision kind of freaks me out a little bit. I think we're probably going to have a decision or a case law that comes up in the future that addresses that piece. But I definitely would say terminal illness is a lot like PVS, where the person is going to pass. It's really a matter of how much medical intervention we give them to extend that passing or to make them comfortable. So I think it depends on the circumstances of the illness. I'm sorry that wasn't the greatest answer to your question, but it depends. That's the lawyer answer. It depends. Yeah.
What is the non-medical end-of-life question? So a case where you've got, a client who has no one. They are 11. They kind of always live that way.
Mm-hmm.
And this is a trust, not a conservatorship. And the woman is asking for, I don't want to die alone. She's, being in a country, she wants to be there more for her. So how is a fiduciary really try to provide a level of service that she's asking for within the constraints of other clients that you have, yet not wanting it to look like a conflict of interest that,
You're creating work for yourself.
you're like 5 hours, 6 hours sitting there with her, but that's what she wants to be there with her hands while she just spills out the end of her life conversations.
That's a really good question.
What
The question was, you have a trust beneficiary or someone who is facing end of life and who is becoming progressively more needy or wanting of your one-on-one attention because they're feeling lonely in the process of passing and they just want somebody around because they don't want to be alone. And how to handle that since you're charging for your time and it sort of conflicts with how do you document that so that you don't look like you're creating work for yourself. And I would say it's hard. How does she contact you? By phone usually, or mm-hmm. Right. So, witnesses are always good. Billing your time appropriately, being very descriptive about, when I spend an extra amount of time on something, I'll put lengthy telephone conversation with so-and-so, or multiple this, or, extensive review, or you might say, extended visit with trust beneficiary at her request for X, X, Y, and Z, just to have the paper trail there that you were aware of it and that you've documented that it was important and requested by her. I mean, she's not going to put something like that in writing for you. And, ultimately, can somebody contest your fees? Sure. People can contest whatever they want. But having good documentation and being able to recount remember your steps and why it was that she asked you on that particular time, and having maybe a hospice worker that's there to witness her making those requests of you, that might be worthwhile. They might not be very happy about signing a declaration for you if it ever got taken to court, but yeah, I mean, if it's really a lot of time, and it's happening over and over and over again, then I don't know, it sounds horrible because I hate billing people. I hate that we are paid, especially in conservatorships, we're paid from estates where people had no control of putting us in charge. And I just wrapped up a case. Well, I didn't wrap it up. It's going to keep going. But we just had a fee petition in a local county for over $160,000 for 4 attorneys for setting up a conservatorship. Yeah, I was really offended. I mean, I was like, that would never happen in my county. But similar, you just want to show that you're aware of the situation and that you're making efforts to, be reasonable in your attempts to cut your visits, make them appropriate time lengths and that sort of thing. But you might want to, maybe a less expensive option would be to pay for a sitter, somebody to just go and converse with her. You guys have those ideas. I don't really get to.
Well, that's the problem. If the client wants her,
Right.
the emotional attachment is to her, just anybody.
Right.
Were you going to touch upon the end-of-life option act?
No, because there was a separate talk on that at the conference. And End-of-Life Option Act is only something that is contemplated for people with capacity to do it for themselves. So you're not going to see that in a fiduciary capacity in my understanding of the situation.
Did I understand right that a conservator cannot sign a policy
Correct.
and does not have the ability to sign an agreement with the hospice?
I said that one, it depends. Yeah, it depends on the reason for hospice and the care plan for hospice, whether it's an aggressive withdrawal of care. It's something that you should possibly confer with your attorney about. But I have a number of clients who initiate hospice for their conservatees and their trust beneficiaries or their agents under power of attorney, and there's has been no issue, but it's technically a withdrawal of care.
So are you saying that if a person is in a conservatorship, and then the doctor says that it's time to sign a pulse, is it without a conservator's signature?
No, you can sign a pulse that says full code, but that's it.
You've been talking about, in our discussions has been about the withdrawal of life support and things like that. But I'd like to get your opinion on something completely different, and that is, how would you advise a conservator who is a conservator of a person who has been diagnosed with psychotic mental health disorders, and that person also has physical disabilities and refuses medical treatment? What is the conservator to do in that case?
Well, you're probably going to be thrown into the 5150 world and LPS conservatorship and have to contemplate managing both. Not all fiduciaries do LPS conservatorships because they're very stressful and they're very limited. If you have an LPS conservatorship, you can't make medical decisions for that psychiatric patient. You can only make psychiatric decisions for that patient. So you need to have a conservator of the person in tandem with the LPS. But you're likely going to, you may be the person who has to 5150 the patient, the conservatee, call into 5150. If they're refusing, if they're acting in a way that causes themselves or others harm, you may have to involve a 5150. Well, you would call law enforcement to come out. Right. You can't say you're under 5150. I'm taking you it. No. Sorry if that was miscommunicated. No, you would make the 911 call, or you would make the call to the law enforcement to come and effectuate that for you. That's what I would recommend doing.
The police cannot make them go into a hospital unless you have an LPS conservatorship.
The police would take them to an emergency room.
No, they won't. They won't. The police cannot take them to an emergency room.
They do. It happens at all of our hospitals. We always get them. Yeah, 5150 is for 72 hours. Then they have to recertify. If they don't transfer to a psychiatric facility where they're held and recertified for a 5250 for 2 weeks, then they usually come up with new grounds to rehold them again on a 5150 to try to find a discharge plan. But LPS is tough because usually you have to go through the month and a half of recertifications to get the LPS imposed, and they're only good for a year, and they have to be re-upped every year. And it's a separate part of our probate department. Any other questions? You guys are doing awesome helping me get to the end of my presentation time. Yes?
I'm having a hard time understanding how the conservative can have enough, they're conserved, so they have lost, capacity. But who is to decide they have enough capacity to sign a post? Because that's what you're looking for. They want the conservative signature.
So what I would do in that situation is you might be, if you think your conservatee is potentially, is talking very coherently to you about this post idea and is really engaging, and maybe their capacity comes and goes, because sometimes conservatorships are imposed for people that don't have consistent capacity, but they have ups and downs and that sort of thing. So one of the things you might be able to do is to petition the court to carve out a piece of your medical decision-making authority which would enable the conservatee to sign the post.
But couldn't they make the argument that he may not have been in a cognitive...
Oh, certainly. But you'd have to argue that they would. You'd have to argue that it would be under doctor's supervision and that the doctor would first confirm that he or she had the ability to weigh the risks and benefits of the decision. Because, when we file these conservatorships, we do the cap deck, right? The judicial form that's a checkbox or whatever. It's not, I don't think it's rocket science, and I think a neuropsychologist report is hands down 100 times better than that thing. But it does establish that they lack the capacity to make medical decisions for themselves. That's the baseline. So when the court gives you the authority as the conservator of the person to make all those medical decisions that we discussed in 2355, you might be able to go back in essentially amend or revise your authority under 2355 to be subject to a post that is signed by the conservatee or something like that. Talk to your attorneys. It may be a way to, if you have a patient, or excuse me, a conservatee in that situation, to handle that early on in the conservatorship and then have that be part of the court record even. Yes.
But I think like in my case, she never had capacity.
Right.
She couldn't communicate or
Right.
anything. And had I known that then, I mean, fortunately, it turned out kind of the way I think it should have, I probably wouldn't have taken that case. Because the idea that you're going to let a person go through what she would have gone through,
Right.
it would have been tough, knowing that the person, her daughter, did not want that. So I think, again, I'm gonna reach out to my care manager now to say that
Yeah.
you're having all these other people signing posters with a person who could not communicate what you wanted.
Right. Well, so they were having her sign the post?
No, the care manager that was on that case with me had like 10 or 12 years' experience at the time. She was the one, I'm not blaming her, but
Sure.
I'm just saying she had that knowledge of, yes, let's go ahead and do this at the doctor's appointment. The doctor knows, the client, the patient really well. So between the three of us and talking to the daughter,
Yeah. But this is that kind of gray world purgatory that hospitals kind of operate in, because the next of kin stuff that I put in this presentation, there's no law that says the next of kin can make decisions. This is hospital created law, that they're comfortable with their risk exposure to do this. And all of them do. Every single medical facility in the state of California does it this way, and they all have a policy that even probably has priority of which next of kin we're going for. But there's nothing in the health and safety code, there's nothing in the probate code, there's nothing in the civil code, there's nothing anywhere in our books, our law books, that says that next of kin have decision-making authority.
they had this ethics committee.
Right,
And I received a copy of their document.
right. And the ethics committee rarely, they rarely can get past paternalistic versus, I don't know. They're helpful because they show that the doctors are trying to be collaborative, but they often don't all agree, and sometimes they don't produce conclusions. They just kind of say, work it out, but when something gets to the ethics committee, that they're really tossing it back and forth and trying to figure out how to move forward. But no, but that's that, again, it's that gray area of entity-created laws that just kind of happens. Yeah, you have to stand up for yourself, and you have to say, look, I am legally appointed to do X, Y, and Z. I am a pseudo-court official, and I'm not going to jeopardize that by succumbing to this pressure or whatever. I went to a presentation that says I don't have to listen to you. Any other questions? Thank you all for being so...
Well, it goes out the window when you've been appointed to have authority to sign on someone's behalf or to make substituted judgment, and you really don't have that authority with the post, right?
Well, it's specifically end of life only. Every other thing, residents, visitors, education, clothing, nutrition, without withholding nutrition, all those things you have full discretion. It's just the end of life piece. Are we done? Thank you, everybody.